Thank you for joining. The webinar will begin in a few minutes. Thank you for joining. The webinar will begin in 1 minute.
Hello, everyone, and welcome to the Bend Chamber of Commerce Impact Series webinars. Happy to have everybody with us today on this glorious day outside. About time, I just want to say, to see the sun around these parts. Today, we have a great program for you, very timely as we enter into phase 2. We'll hear from our regional economist, the infamous Damon Runberg, about the current unemployment numbers in the state, more specifically in Central Oregon. And then today we're also bringing in 2 employment experts to talk about return to work issues as you all go through the experiences of going into phase 2 and the next iterations as we move forward through the pandemic. First, I'd like to thank our Impact Series sponsor, Ben Broadband. So their investment has been really great. It helps us bring this information and these conversations to you. And we've been doing it since March, since the pandemic and the lockdown happened. And we're very, very grateful for their assistance and their support. So be sure to check your follow-up email later today. Ben Broadband is offering a chance to win a $100 gift certificate to Newport Avenue Market. And if you don't want to use it, you can contact me and I will do that for you. A few housekeeping items before we begin today. If you have a question for the panel, we would love to hear it. Please put it in the Q&A section, not the chat section. And that way I can take a look at it, monitor it, and ask the questions. Sometimes we get very similar questions or there is a theme. I'll try to aggregate that, but we'll try and get to as many as we possibly can. All slides and reference sources will be available after the webinar is through, along with a full recording of the webinar. And we'll also send you a link that we have been developing of vendors in the area that we've been curating that have PPE, sanitation, supplies, etc., that will help you into phase 2. And there's also information on a local product from Valor that is on the list for EPA certified solutions for viral disinfectants, and many other resources on that resource page we'll send to you later. On to our first speaker. So our first presenter today is Damon Runberg. He's our regional economist with the Oregon Employment Department, and he has been on our webinars before. We know him, we love him, except he's probably not gonna have great news for us, but we're sure gonna appreciate getting the information. Damon, thanks again for coming.
Hey, thanks, Kate. Thanks for having me. And I don't know, the information is looking better and better every day. So it might be, it might look better than you might think at this point. Let me jump up here. Give me a thumbs up if you're seeing the slides. There we go. All right. Well, it is an interesting time right now with The labor market, we obviously had this massive closure, this huge shock to the system with the COVID-related closures, and we've slowly seen the state of Oregon reopen in various phases. Here in Central Oregon, we're in phase 2. Shouldn't be news to most of you out there. Things definitely are feeling a little bit more like normal. Hopefully we're all wearing masks in public. But besides that, other parts of the state are also starting to really open up, and now we're getting notifications that Multnomah County, the biggest, most populous county in the state, is moving into phase 1 here soon. So pretty soon, this whole reopening framework is going to be something that all Oregonians are experiencing, and that means a lot for transitions from this period of really high numbers of unemployment insurance claims to hopefully moving towards fewer claims. So if we're actually looking at the number of new initial claims that have been filed in Oregon in the now months of COVID, we see the weekly claims here where it just ramped up really aggressively early in March and through April. And then you can see a little bit here. This is just a total number of all the claims filed. As of the second week, or the end of the first week, I should say, in June, nearly 450,000 Oregonians had filed a traditional unemployment insurance claim. 450,000, just a mind-boggling number. The good news is, we'll get to in a second, we'll switch to how many are actually currently on unemployment insurance. It's not that big of a number. A lot of folks were only on a UI claim for a few weeks, and reopening has definitely helped move the needle there. But this also sort of underrepresents the folks who are receiving benefits today. The Pandemic Unemployment Assistance, the PUA program, is a program for self-employed folks. They're not counted in these numbers, and other folks who don't qualify for unemployment insurance benefits are obviously not counted here. So the impact was severe, and it was really spread across a lot of the labor market in Oregon. But we're sort of transitioning to a new indicator, and we're talking about unemployment insurance claims. We want to start talking more about continuing claims instead of new initial claims and adding those up over time. We want to get a better idea of the number of people who are on unemployment today as of this week, or really it's lagged by a week. So last week, what did that look like? And what we see is that in that first week of May, so the week ending May 9th, the number of Oregonians on continuing claims, once again, that they had continued in the current week as well as the previous one, so they're continuing that claim on, peaked at 309,000, just under 310,000 Oregonians on these claims. Once again, just a massive number of folks who are claiming from one week to the next. Now, you might notice there was that dip after that peak, pretty subtle dip, but that was the first week of phase 1 reopening. We opened in May 15th, and 2/3 of the state really moved into phase 1. So you could see that actually moved the needle there. We actually saw fewer people on continuing claims after that first week of phase 1 reopening. And as we've moved forward, we've seen those numbers of continuing claims start to trickle down slowly. We're sitting, as of the end of the first week of June, we're at over 275,000 Oregonians still on continuing claims. So there's some good news and some bad news here. The good news is that phase 1 and later phase 2 of reopening have moved the needle. We've seen fewer people on unemployment insurance, and we've definitely stopped seeing the increases in folks on unemployment insurance. The bad news is it barely moved the needle. If anything, it pumped the brakes, and we've sort of flattened out here. We're not seeing increases any longer, but we're definitely not seeing the decreases that we sort of would have anticipated based on the level of the phase 1 and phase 2 reopenings that we've seen. However, the good news that we've seen, and this came about nationally about a week and a half ago, it shocked just about everybody when they saw the unemployment rate nationally had dropped in the month of May. Pretty much every projection out there, anybody you asked would have said that the unemployment rate in May was going to be higher than what it was in in April. And the reason why this was such a shock was because everyone was using unemployment insurance claim data as sort of a projection or indicator where the unemployment rate was going to go. Interesting, what we saw was that it turns out that some states actually started reopening before Oregon, so that really moved the needle nationally. And it turns out even that first week, our reference week for the unemployment rate is the week that includes the 12th of the month. That turns out that is exactly the week that Oregon moved into phase 1 of reopening, and it moved the needle. Now, we won't say it substantially moved the needle. In May, Oregon was sitting at 14.2% unemployment compared to 14.9% in April. So yeah, it looks better, but we're not going to sort of celebrate that too much at this point. That's still really historically high rates of unemployment across the state. But once again, the good news is that reopening and moving into these subsequent phases of reopening have really moved the needle as far as the labor market's starting to improve, at least modestly at this point. If we zoom in on Central Oregon a little bit and actually look at what the claim activity has looked like here locally. So once again, this is the number of new claims that have come in by week for the Central Oregon counties, the Tri-County area. Once again, you can see sort of that late March, early April was where we really saw the peak number of folks filing for unemployment. And once again, as a reminder of dates here, so Central Oregon moved into phase 1 on May 15th. So that week you see there ending in 5/16, a noticeable drop from what we saw in the previous week before that. So once again, fewer people were filing for unemployment due to the reopening, moving the needle there. However, what might be the most concerning when you look at this graph is we continue to see relatively elevated, especially, I mean, compared to normal times, these would be, incredibly high numbers of claims. But even in the COVID world, like considering the fact that we're now into phase 2, to see an average of nearly 800 new unemployment insurance claims coming in a week for Central Oregonians is quite shocking. It is concerning to think that we might be moving into the next phase of this COVID recession, which is the vast majority of the layoffs that occurred were identified as temporary layoffs. Well over 3/4 of those unemployed are, it was closer to, like 80+%, were actually folks who are on a temporary layoff. The concern here is that the longer these impacts go on, the more likely that these layoffs are turning into or transitioning to permanent layoffs. And that is a little bit of the concern we see here with the tail of this graph, where we're seeing elevated rates of unemployment insurance claims after we've entered phase 2 of reopening in Central Oregon. So we're gonna have to keep an eye on this one, but at some point we knew that this was gonna lead to a more substantive traditional recession, and we might start seeing that in the numbers here. And ultimately, it's important to remember that Central Oregon is really being disproportionately affected right now compared to other parts of the state when it comes to layoffs right now. It has everything to do with the industry composition that we're seeing. So Central Oregon has a slightly higher share of leisure and hospitality jobs here in Central Oregon compared to the state as a whole. We also have a high concentration of healthcare jobs, and personal care services are actually, believe it or not, we do that pretty well here too. You put that all together, and nearly 20% of the labor force in Central Oregon filed for an unemployment insurance claim in the first 12 weeks of the COVID crisis. It's not the hardest hit. The hardest hit continues to be the North Coast counties, where nearly 1 in 4 folks within the labor force filed an unemployment insurance claim in that first 12 weeks of the crisis. So one thing I want to share really quickly, we have some really interesting information that's coming in from the US Census Bureau. So typically, most of our economic indicators are monthly data, and that's usually sufficiently fast for us to understand what's going on. And like I said, we've talked a little bit already about some of the unemployment insurance claim data. We've been relying on that more and more as a means of sort of better understanding what's going on when these changes are happening so rapidly. But the Census Bureau, in response to what was going on with COVID, created this weekly survey, which is a big deal. And they're publishing estimates for states and large metro areas. We don't qualify here in Central Oregon as a large metro area, but we don't get any sort of local information, but we do have statewide sort of responses of what the business impacts due to COVID have been on a weekly basis. Maybe no surprise to anybody here, but the vast majority of businesses across the state of Oregon have been impacted in some way by COVID. Really going back to what we're talking about, how the phase 1 of reopening really moved the needle, it flattened the curve of unemployment and actually started to see some improvement there. We saw that the peak of impact identified by businesses was in the first week of May, so the week of May 9th, where somewhere around 93% of all businesses across the state said that they were impacted in some way. And the good news, like I said, this is starting to tail off a little bit here, but there's still a lot more orange than there is green in this graph here. So we continue to see a lot of businesses being directly impacted in some way by COVID. The beauty of this survey is they actually give us some really granular understanding of the types of impacts that businesses are feeling these days. And so no surprises at the top of the list. What we see here is decreases in revenue. during that sort of the peak week, the worst of the COVID impacts, 68% of businesses in Oregon said that they were seeing a decrease in revenue due to COVID. That has improved quite a bit, actually, and you can see now to 55%. But we're still talking over half of the businesses in the state of Oregon are saying that they're having their revenue is down from what they would expect based on COVID. Now, what does a decrease in revenue for a business transition into? What does that mean for us? Well, it clearly means that there's a lower demand for labor, and so that's transitioned into a few things. The second highest impact that's been identified, has been a decrease in hours for workers. At the peak there, 45% of businesses said they decreased the hours for their workers. Still today, or I should say at the end of May, that was still nearly 1 in 3 businesses identified that they were still decreasing hours for their workforce. This is a really important thing for us to understand, because we have been talking about unemployment rates and the impact on the labor force. Technically, we've sort of been thinking of it like an on-off switch. You're either employed or you're unemployed. And when we see these impacts here in decreased hours, we realize that the impact to the labor force is far greater than we sort of realize, because there are a lot of people out there who didn't get laid off, who actually might have just seen their hours cut. And nationally, we have a little bit of a way to gauge this. We know that it's an economic term called those who are employed but working part-time for economic reasons. That was around 500,000 people before COVID who identified as working part-time for economic reasons. Now we're at nearly 11 million nationally. So we had an increase of over 10 million Americans who went from being employed full-time to employed part-time for economic reasons, getting their hours cut. And this is where sort of sometimes the unemployment rate doesn't really do justice to the true impact that we're seeing right now across the labor market. And then below this, the last two we see here are temporary closures and decreases in employment. It's important to realize that these are two separate line items. So if you closed your business, you clearly had a decrease in employment because you have no more employees that you're paying. And then some businesses decrease their employment, say a restaurant that went from 50 employees down to 10 employees during just a takeout service. So these two kind of stack on top of each other and really give an idea of the depth or the share of businesses who cut workers in some form or fashion, whether that's because the business closed temporarily, like I said, or because they just let part of the workforce go. So the final question that they ask businesses in this survey is sort of a forward-looking indicator. We don't want to lean too much into the responses, but it does give us a little bit of insight into what the perspective of businesses is today across the state of Oregon. So the question is, how much time do you think will pass before your business returns to its normal level of operations relative to 1 year ago? Pretty simple question, and getting into the minds of businesses across the state. And I'll say there's some hope and a little bit of fear in these responses that we'll see. So we'll start with the good news here. The good news is that in the next 6 months or less, 41% of businesses in Oregon think that they'll return to operations that they had a year ago within the next 6 months or less. So that's pretty awesome to hear that a huge chunk of businesses, this very much is a temporary blip on the radar. COVID has been brutal and devastating, the impacts there, but a lot of businesses are anticipating going back to normal, and that's a great news for workers in the labor force more generally. Here's the bad news. Here's sort of the terrifying number. 13% of Oregon businesses said that they anticipate they will never, I repeat, never return to levels that they saw in the last year. It doesn't take a huge number of businesses. You know, we tend to think, oh, well, you know, the unemployment rate's 14%. That's really bad, but you know, we can drop it down and below double digit and we're going to be good to go. It's good to remember. It's important for us to remember that even 13% of businesses not going back to normal is a devastating recession, is what that is. And we're in a completely different ballpark right now because of the impacts of the pandemic. But if this is true, if 13% of our businesses statewide never see a recovery in any way, it's something for us to be concerned about in the length of what this recession might be for us. So maybe I should have flipped those and done the good news one first, or second, and the bad news first, so that I don't leave on a sort of depressing note there. But it does seem increasingly like we're moving into more of a traditional recessionary mode right now, as we are moving out of sort of the COVID restrictions across the state. So one thing that I want to hit on really quickly, and I know the topic here is reopening and what that means for businesses. And one of the questions that I get routinely from businesses is, I'm coming back, I'm opening up my business, but people aren't coming back to work because the unemployment insurance benefits that they're on are very generous. And with the CARES Act that extends an extra $600 a week to folks who are on unemployment insurance through, I believe, July 25th. Yes, it is very generous, especially for those folks who are lower wage workers, those near minimum wage. Many of them might be making even more than they were beforehand. So the question is, what do I do about these folks who refuse to come back to work? And there is actually, there's some wiggle room here. So technically we would say, well, if someone refuses to come back to work, they're no longer eligible for unemployment insurance benefits. You can't be offered work and still get unemployment. However, there are some exceptions to that rule in the world of COVID, some temporary rules that were put into place that allow folks to still have unemployment insurance benefits, even if they're called back. But they're very specific rules that are temporary rules that are in place. So I won't run through them, in too much depth here. But first, if you're sick from COVID, you could still stay on your unemployment insurance benefits and stay at home. That's good. We don't want people going to work if they're sick with COVID. If they've been exposed through tracing or tracking to someone with COVID and are now have to be in mandatory quarantine, they also would be able to maintain their benefits. If you're staying home to care for someone because they are sick with COVID, you also can keep your benefits. Also, this is sort of the biggest group is going to be this fourth bullet here. Unable to work because they have to stay at home to care for a child due to the closure of schools or childcare facilities. This is one that's pretty concerning in the long term. Just what does it mean to get sort of workers back in the workplace when our childcare facilities are still, many of them are still closed. Now we're in summer break, but what does the fall look like when for school districts, and are we going to be able to get kids back in schools and allow those parents to go back to sort of normal work life? And then sort of the last couple there are due to sort of personal health reasons identified by a healthcare provider. You could also sort of continue to maintain your benefits. So big story is if you call your workers back, most of them need to go back to work, especially if you're following social distancing guidelines laid out by the state. If you have any concerns, if you're worried and you want to let the Oregon Employment Department know or unemployment insurance staff know that you've called these workers back, you've met all the criteria, and those folks are still not coming back, there is a link here that I've included. That is a form that you can fill out. It's an internet form. Fill that out and send it, and it will go to our fraud department, and they will assess whether or not someone is still eligible for those benefits or not. It is not a business's responsibility to identify eligibility for benefits, but the employment department does appreciate when they get some insight or some hints that someone might be submitting fraudulent claims. So that's that link there. If you have any questions about that later, we can chat. I'm going to be done now and transition it. We're not going to do questions with me right now, but my contact information is here if you want to call, email, or follow the conversation on Twitter. And I'll send it back to Katie.
Great. Is that you on top of the rock?
It's my brother. Yeah.
Really?
Yes.
Cool.
I'm not that brave.
It's a great picture. Thanks so much, Damon. That was really insightful information. Fascinating.
My pleasure. Thank you for having me.
Have been combing through. Really appreciate all the work that you've been doing. So next up, we have two experts in the area of employment law and regulations to discuss some of the barriers to employees returning to work, resources to help employers, and how to navigate some of the turbid waters that are ahead of us as we try and get through this phase 2. So Jeffrey Burgess is the training development specialist for the Bureau of Labor and Industries. And Kurt Barker is an employment law attorney and partner at the local law firm Carnot Peterson. And really appreciate both of you being here. And I'm going to let you folks take it away because you know who's up first. Somebody need to be off mute. And there he is.
Hi, everybody. Thanks, Katie. Thanks, Damon, for that really interesting presentation. And it's my pleasure to be with you all today. I would just as soon be over there in beautiful Central Oregon in person, but this is the new world in which we operate. And happy Juneteenth, by the way, to everyone. These are spectacularly interesting times, and there are interesting challenges for employers. Just a word about what we do and who we are at Technical Assistance for Employers. We try to help folks figure stuff out in terms of navigating the perilous waters of state and federal employment law. We can't give you legal advice, but we can answer questions. We can give you information about what the statutes, rules, and cases say. And we're happy to defer to counsel when a question comes up seeking legal advice, which is about 100 times a day. We've been pretty inundated with phone calls and emails, but the good news is we're getting caught up, and it's been really refreshing to start to hear questions about something other than COVID-19, like final paychecks and family leave. And yet, as we're finding that we're getting back into more core concepts, coronavirus is permeating just about everything that we have to talk about and the concerns that employers are having. So there seems to be some light emerging from the end of the tunnel, but return to work issues are particularly critical. So I'm tag teaming with my friend and colleague, Kurt Barker, and when folks need legal advice, he's a great resource, and folks like him that do legal work. I used to do that work for 22 years, and it's a little different gig, but let's talk about some return to work issues. So Kurt is driving the bus, so if he could advance the slide here, we'll look at the slate of offerings in the short period of time that we have today. We won't be able to do the deepest of dives. We're going to talk about the governor's orders, where we are with phase 2, just really quickly, and then get into the face coverings issue and some safety considerations. Safety is no accident, as they say, and so with good planning, clear communications, we expect that employers can have safer, healthier workplaces and really reduce a lot of the fears and anxieties that employees have. Then Kurt is going to take over and talk about lack of childcare and the Families First Coronavirus Response Act. Disability accommodations is a really interesting concept, and what happens when an employee refuses to come back to work. And then I'll finish up with a discussion of harassment and discrimination that fits, I think, fairly nicely into the discussion. So the Governor's Executive Order 2012, Stay Home, Stay Safe, really dramatically impacted employers, but we're emerging from that, and even Multnomah County is emerging substantially from that as we speak. So fortunately, many counties, I'm in Yamhill County presently, and we're in phase 2, as is Deschutes County. Let's take a look at where we are and what that means. And I put a link here. Unfortunately, it's not a hyperlink, but I think Talina is going to send out links to everybody after the presentation. So if you're trying to click on that, sorry, it doesn't hyperlink for you, but that is a fairly updated set of information with all kinds of links embedded in it from DHS and the Oregon Health Authority. So I strongly recommend that folks look there for resources all over the map, state and federal. And so where are we with phase 2? This is where expanded gatherings are permitted so long as social distancing can be, or physical distancing can be maintained. We're seeing now that it's possible to be social without being physical. So physical distancing, I think, is a preferred term, and bars and restaurants can stay open later. Doesn't affect me because I'm in bed by 10, but that was the old phase 1 cutoff date. So this gradual reopening really presents opportunities, risks, challenges, and frustrations for employers. And Kurt is going to talk about when those employees maybe could come back to work but don't, or when they have good protected reasons for not coming back to work. So it's really important that employers look at this new normal as opportunity for expanding telework opportunities, staggering shifts, rest and meal periods, so folks aren't congregating in certain areas, and then doing deep cleanings in terms of commonly touched areas, doorknobs, handrails, copy machines, and the like, and then encouraging folks to do some things like more intensive hygiene, hand washing more thoroughly probably than they've ever done before and more frequently. And what about face covering? So really the governor's orders break that face covering piece down into three sub pieces. There are masks, which protect the wearer, like the N95 respirator masks that we've heard it so much about and have been in short supply. Those really aren't in play other than for first responders for the most part. But then there are face shields, which is generally a clear plexiglass shield that is at some short distance away from the face. And then there are face coverings, just the simple cloth coverings that can have a significant impact on reducing the spread of COVID-19. On that link that was on the slide earlier, there are examples, templates of signs that you can post in around the workplace, encouraging employees, customers, and visitors to wear face coverings. And that's just a really good idea. We want to educate folks on those procedures. The reuse of face coverings, for example, and it's important to note that some folks may not be able to wear a face covering. And when the governor's orders first came out, they didn't make an exception for folks with disabilities. And we've gotten all kinds of calls from employers about, hey, I've got an employee with a respiratory issue and the face covering makes it more difficult for them to breathe, or wearing a face covering is a trigger to my employee's PTSD, and what do we do there? So fortunately, at our request, the governor's office revised their guidance to allow for pre-existing employment law that requires employers to make reasonable accommodations for folks with disabilities. It's important to note too that despite the fact that someone might be able to wear a face covering, we might have a customer or a coworker who has to read lips to communicate and look at facial expressions to communicate, and we want to have some protocols in place for that. And it's not a one-size-fits-all approach. It's going to depend on the nature of your workplace and whether someone can be asked to step into a more well-ventilated area or an area where folks are congregating less so that we can remove the face coverings and communicate more effectively. All right. So the Centers for Disease Control has really outlined a lot of best practices, and let's look at some of those. And then we'll look at some of the EEOC's guidance as well. So taking temperature, it's a great way to assess whether somebody is currently experiencing symptoms, and assessing those common symptoms, flu-like symptoms, including body aches, fever, lack of the ability to taste and smell has emerged as a common symptom. But it's important to know that lots of folks are asymptomatic and can still be vectors or carriers for the disease. If somebody becomes sick during the day, we want to send them home immediately, and then consider the nature of their illness. People want to soldier on and come into work, but if they're going to get everybody sick, that's bad for everyone involved. So good ventilation is important. And we want to encourage folks, if they're sick, to stay home. And that's what Oregon sick time is for. And then I talked about common cleaning as well. So let's look at the next slide. The EEOC, the Federal Equal Employment Opportunity Commission, has implemented some guidance. And they are the federal civil rights organization. They work in partnership with our agency's civil rights division. And so we look to them for guidance in a lot of areas, including this one. We certainly cannot ask about disabilities during the hiring process. We want to have a mechanism in place for folks who are applying that have disabilities and need to have some accommodation to get through the hiring process, but no medical inquiries pre-employment at all. We can subject successful applicants to post-offer pre-employment testing, as long as we're not singling folks out based on their protected class status. And if all folks who are successful applicants in the same category of jobs are given the same tests, then we're okay there. Then once we have an existing employment relationship with folks, we can require medical inquiries and testing if it is job related and consistent with business necessity. So we kind of know it when we see it. A really important counterpart to when we get very sensitive medical information about our employees is that we've got to keep that confidential in a separate medical file, or if we're going paperless, in a separate computer file that is encrypted and password protected. All right. We can take the temperatures of employees, but having a protocol in place for doing that is a good idea. The forehead scanner is certainly less invasive, and remember that some folks are going to be asymptomatic. So to the extent that someone says that they can't wear certain personal protective equipment because of a disability, that's an opportunity to call a timeout, have a conversation with that employee, engage them in a meaningful interactive process. And Kurt is going to talk about disability issues in a little more detail in just a minute. Vaccines, we don't have a vaccine yet. We wish we did, but whether it's the common flu vaccine or some hopefully soon arriving coronavirus vaccine, we want to be sensitive to the fact that some folks based on protected class status will have an aversion to vaccinations, and we have to tread lightly there. We can encourage it, but we cannot require it generally, even if there's a strong business necessity for doing that. So we can advise our employees that some folks are not going to be vaccinated, but we want to identify who those folks are, because we shouldn't share protected class status information with others. So I have a former colleague who was fond of saying the three most important principles of supervision of employees are communication, communication, and documentation. That third one's important because if we don't document, it's as though the communication never existed. But we really want to engage our workforce and let them know what we're doing and why we're doing it, and remind them early and often that our commitment is to safety and here's what we're doing. And we want to encourage folks who are in the trenches doing the work to let us know if they see something unsafe. We don't want to discourage that line of communication, because if they don't get a satisfactory response from us, their next call may be to Oregon OSHA or the Federal Occupational Safety and Health Administration, and that could result in an enforcement action. So this two-way dialogue is important, and we want to make sure that we're not tolerating and we're vigilant for retaliation and discrimination against protected groups. We're seeing that among Asian Americans. There's been a spike because of the origins of coronavirus, and whistleblowers and folks with disabilities and older workers. So those are the kinds of things we really want to be mindful of. And so if you've got questions, keep us in mind and keep in touch as you go along, and we'll try to help you navigate and let you know. If we think you're about to step into some dangerous territory, we'll encourage you to talk with counsel.
Okay, so Kurt, I think you are up on the deck. Are you?
There you go.
There you go.
Thanks. Thanks, Katie. Jeff, that was great. Damon, thank you too. It's great to see you both. As Central Oregon finally starts to see summer, we're getting a flood of questions about employee childcare needs. And what do these new laws mean? What do I have to give my employees? What could I give my employees? You name it. This is a real technical part of the talk today. I apologize to everyone for what I should probably describe as acronym hell. But we're going to go through some of these new laws, and with a particular focus on childcare and what that means, what you have to give your employees. The landscape now is really unprecedented. We now have a form of paid protected leave that has to be given for certain childcare needs. And really nothing like that has existed in the past. I mean, in Oregon, we've had some provisions where we have to give an employee leave if they've got a sick child under OFLA, the Oregon Family Leave Act. But this is brand new stuff, so be careful not to step in it. The two things, just to get this out of the way, the two things that we lawyers are most worried about are going to be retaliation and interference claims. I expect a wake of those coming down the road as these new laws play out. What do I mean? A retaliation claim would be, I used this new emergency paid sick leave for my child care. or I asked about it and you gave me a hard time, or you fired me for it. That's a retaliation claim. Interference claims, or watch out for those too. That's a suit that's based on you knew I was eligible, you knew I had a need, and you didn't offer it to me, or you denied me access to this leave. Both can lead to claims, so that's what we're here to help you avoid. The emergency paid sick leave, this is part of the new FFCRA. It's going to apply to most of you though. Those of you with fewer than 500 employees, there's some notes on here about eligibility. And again, your employees are eligible for this new paid sick leave benefit. They're eligible on their first day of employment, so watch out for that. Do keep in mind, I forgot one critical part of the big picture here. These new laws, they're in effect, these childcare leave laws, really from April 1 through the end of this year. So I'm sure you're with me in that I can say I've never worked so hard to understand a new law that I know I'm going to want to jettison out of my brain come January. We'll see. I'm looking forward to that. Here we go. More on paid sick leave. There are 6 qualifying reasons. I'm not going to read them all to you. Again, our focus today is on the collision of summer break and your workers. So let's focus on that reason number 5. If the employee is asserting a need to care for their son or daughter, and they're under 18, and their school closure or care provider unavailability is because of COVID-19, this stuff can apply. So that's the key thing to watch for, is the school closure due to COVID-19. Real clear benchmark on that is summer vacation. That's not a COVID-19 reason. Schools are closed right now, most all schools, because of summer, not because of COVID-19. Now, so that means your employee who's struggling to find healthcare, it's too expensive, I can't find it right now, etc. If the loss of their school program is just because of summer and not a COVID-19 specific reason, you do not have to offer them this new paid leave benefit. And fair warning, if you're just generous and give it to them anyway, you might not qualify for the tax credit. So let's get back to what's happening here in Central Oregon this summer. A lot of clients are asking, what about summer camp closures? Well, if the closure of the camp is due to COVID-19, and that was the childcare plan, I planned to send my son off to camp for the entire month of July, then that period of time in which their child cannot attend summer camp, that could be eligible for this new paid leave benefit under emergency paid sick leave. So keep that in mind. Summer camp could qualify if that was the childcare plan. Now, I'm not going to go through all the details on what they get, but just keep in mind the bottom bullet here applies to childcare. It's 2/3 of their regular rate of pay with maximums. That's what we're talking about, what you would have to pay them if they're eligible for this leave. All right, there's another component of the FFCRA law that provides what we call FEMLA Plus, or EFMLEA. That's up to 10 weeks of leave. And again, this is going to be paid at that 2/3 rate. But one critical source of client confusion that we've seen is the only reason for which an employee can invoke FEMLA Plus, this new 10 weeks of 2/3 pay. The only reason is reason 5, childcare. And again, it's only if the closure is due to COVID-19 reasons, or if their provider's not available because of COVID-19. So watch out for that. Different eligibility requirements for FEMLA Plus. They have to have been with you for 30 days. Watch out for that too. And again, you're supposed to get a tax credit for this. Do it right, take the tax credit, and you can contemporaneously draw that out of the tax you're paying on your payroll. So hopefully it won't be a huge hit on your bottom line, except you will have that absence to cover for in your workplace. Exceptions, I'm not going to read through all the details of the small business exception, but keep in mind it is a narrow one. Small businesses under 50 might be able to not offer this childcare paid leave benefit if granting the leave would truly jeopardize the business viability. That's a big deal. It's a hurdle that I really have told clients out of the gate they need to be able to show this could shut us down. Finally, the Department of Labor and the IRS can't seem to agree completely on what you need to get verified in writing in order to grant this leave. So this is the Carnut-Peterson smash-up version. Refer back to this list and get it from the employee in writing if they want to use this benefit for childcare. The reason for getting it in writing, not just to cover your behind, but it's to make sure you qualify for the tax credit. If you don't have this in writing from the employee, the IRS may deny you the benefit of the tax credit. All right, a really huge topic right now. You know, our disability laws, the Americans with Disabilities Act and the Oregon Disability Law, they require you not to discriminate, but you also require accommodation. Jeff mentioned interactive process. When someone discloses to you, I think I've got depression from all this. I think I've been dealing with anxiety. You might have a right to get that confirmed from their doctor, but you've got to have a conversation about what do they need and how you can flex to meet that. I'm going to skip to a couple critical areas because I know we're going to run short on time. Jeff, I think you and I are supposed to wrap by about 12:50. One key mistake in this area is unilateral decisions to protect the vulnerable. In other words, hey, we know you're over 60, stay home. We're worried about you, just stay home. Everyone else can come back, but you stay home. Or, hey, you disclosed a lung condition last year, why don't you stay home? We'll bring that back to healthier workers. Sounds like you're trying to do the right thing maybe, but our laws say that is a violation. That's an act of discrimination or an adverse employment action that you're not supposed to take. Now, EEOC guidance that just came out, follow that link if you want to read the whole thing, it's great, clarifies that even if you know they've got a lung condition like that, as long as they're not asking for protection, you do not have to unilaterally do a darn thing. Now, I think it doesn't hurt to keep an open door and mention extra safety precautions, but the guidance has a lot of good detail on that topic. So employees refusing to return to work. What if they've, always watch out if it's a legally protected reason, if it's for this new FFCRA, sick leave stuff or childcare leave stuff, that is a legally protected reason for staying out. You can't fire them for using it. But fear, just generalized fear, hearing a lot of this in the workplace, doesn't constitute a disability. There's got to be a diagnosis in the background. Make sure you're being consistent about your expectations on who comes back, but I had to deal with this for many, that refusal to work can be a basis for termination. I won't read it to you, but I have a template for you where if they've got none of these legally protected reasons that apply, this is the kind of message we've written for a lot of clients. Get some advice on that situation if you have it, but this type of message, maybe giving them 15 days to reconsider, 10 days to reconsider if you can, is a good thing to do. Makes a record that you have an open door to discuss accommodations too. And finally, for those employees who beg, just leave me on unemployment, yeah, you can point out things like, hey, I know I've got to report to the state. I can't let you get benefits if you are refusing work. You can say things like that. Jeff, I think it's back to you.
Thank you, Kurt. That was great. You have a facility for distilling an incredible amount of information into very understandable chunks. So nice work there. Just to follow on to that in terms of preventing discrimination, let's talk about that a little bit more. There are some protected class status categories that have emerged out of COVID-19, race, color, national origin to begin with, as I hinted earlier, disability, age, whistleblower status. And this bit about mixed motive is that you might have a legitimate reason for refusing to bring someone back to work, or for deciding that you need to eliminate a certain category of workers because that business just is not there. You want to make sure you have that legitimate non-discriminatory reason well documented. If discrimination creeps in and is one of the factors in your analysis, then a mixed motive case can arise, and so we want to be vigilant about that. And it might be out of a paternalistic instinct that, oh, we don't want to expose our older workers to health risks, so we're going to wait on bringing them back. Well, it's just like older Supreme Court law where an employer named Johnson Controls decided not to expose women of childbearing age to work in their battery factory, and that was held to create liability for them. And so the best takeaway there is to minimize risk to the extent possible. Inform employees who are coming back of those risks and allow them and their healthcare providers to make a decision as to whether or not it's too risky for them. For us to be overly paternalistic can result in liability, even if we are well-intentioned. So let's look at the science. Let's not play doctors on TV and rely on the information from the healthcare professionals and avoid stereotyping folks. So as with disability, folks might be expressing some reluctance to wear face covering, for example, based on a sincerely held religious belief. We want to take those seriously, even if they don't seem to make sense to us at the time. Engage that employee in good faith in a process, ask questions, try to figure out what's going to work. And if something doesn't work, try something else. We're going to look at retaliation very carefully, and our agency's Civil Rights Division is hypersensitive to retaliation. In my experience litigating cases and working with employers and working at our agency, the big dollar damages cases come not just when there's discrimination, it happens, but when there's retaliation following somebody reporting a health and safety violation, for example. That's protected activity, even if the employee is mistaken. So we want to look at any adverse employment action, whether it's firing somebody, which is the most adverse employment action that there is typically, or cutting somebody's hours or giving them less favorable shifts or work assignments because of their membership in a protected category. That's a recipe for disaster and liability. So employees have a right to be wrong. That's a Joss Stone lyric, but the point to be made there is that someone could have a reasonable good faith belief that they are correct, and then they are in that protected class status. So unless we can prove the negative, which is very difficult, that the employee had bad faith, we should assume the good faith of the employee, even if they're a chronic complainer and even if they are plainly mistaken. We want to investigate all of those claims and complaints, take them seriously and not roll our eyes and give them the heavy sigh and then take some adverse employment action against them. So when we know that harassment, discrimination, retaliation is happening, we've got to promptly investigate, take steps immediately to protect our employees, and take effective corrective action that's designed to prevent it from occurring. And it may be just counseling. We're going to document that counseling or coaching session, that verbal warning, we're going to document that. We may need to roll out some more training, outline more serious consequences if it continues, or if it's something super egregious, it may be that termination is an appropriate remedy for that. And then we want to monitor and follow up to ask the protected person if the situation has gotten better or worse or stayed the same, to make sure that we're being vigilant about retaliation. So I think finally, just a couple of do's and don'ts. Send folks home if they're sick, encourage them to stay home if they're sick, explore teleworking options, do what you can to minimize the risk and following those CDC guidelines, communicate, document. Daily health checks is a good protocol, protect that confidential information. And then some don'ts there that I think are fairly self-explanatory given what we've seen. We want to make sure that we're having the conversations to try to come up with an accommodation for folks with disabilities. And we're going to want to make sure that we're not retaliating against our whistleblowers who might be giving us some good information that that will save us from something catastrophic happening in the workplace.
Great. Jeff, Kurt, Damon, thank you for everything today. This has just really been a wealth of information. I'm going to the Q&A here, and Jeff, while you're still unmuted, if you wouldn't mind taking the first question, any update on predictive scheduling rules? Do you expect the Labor Commissioner to comment again, like what happened in March when she commented on the COVID situation?
It's a great question, and the only information that we have is what was released by the Labor Commissioner in March and the administrator of the Wage and Hour Division, both together jointly came to the determination that this is an unprecedented situation. It's difficult based on this global pandemic to schedule properly, and they're taking a more common sense approach, a less punitive approach. That's about all that we have from them in that regard. But it is important to know that the law is still there. There are substantial exceptions to the additional compensation provisions under the predictive scheduling law. So look at those, call us, email us. We'll try to walk you through them and talk about the potential pitfalls. And know too that effective July 1st, that it's going to be required to give employees 14 days advance notice of the first day of the schedule, what their work schedule is going to be. And this allows folks to make plans for childcare and make other arrangements and plan activities outside of work. And so taking advantage of that voluntary standby list, great opportunity for employers to try to deal with this turbulent and uncertain situation we're in.
Great. Thank you for that. Another question in regards to PUA, pandemic unemployment assistance. Damon, this is probably for you. Do you have any idea when someone who applied for this, say sometime in April, and heard recently the application was received, just recently? We know there's been a bit of delay in a lot of areas of unemployment insurance. When do you expect this person or folks who have applied and are still waiting, if their application is received, will they hear if they're eligible for this benefit and begin receiving a check anytime soon? What's the schedule for this?
Yeah, so I don't have a specific answer for that person, as in, on X date you'll find out. But there was a initiative that started 2 weeks ago for traditional unemployment insurance called Project Focus 100, which is an effort to just jam a bunch of resources into unprocessed claims. There was something like 38,000 unprocessed traditional unemployment insurance claims that were really complicated, and that they were sort of falling behind at getting to those. And in a 2-week period of time, there are now no unprocessed claims in traditional unemployment insurance. So anyone who's on traditional unemployment, you should have had your claim figured out already. And mostly that was a success after 2 weeks of just hammering away at it. So they just announced yesterday, the new interim director of the employment department, that PUA, they're going to do a similar program for PUA where they're just going to focus a ton of resources over the next 2 weeks to process these claims as fast as they can. And so, although I can't give a date, I will say there are a lot of resources being thrown at it. And in theory, very soon they should hear notification about when they'll, whether or not they were eligible or not. And then also the payment should be coming sooner rather than later.
Great, thanks. Couple more questions in the queue. And this is probably for you, Kurt. How liable am I if my employee gets COVID, even if you're following all the steps? We've heard this from a lot of businesses.
Wow. Yeah, that's a scary
Vulnerable
topic.
we are.
We don't want anybody to get it. I think as long as you are following best practices and enforcing them with your employees, you shouldn't have liability for your employee catching the disease, even if it happens in your workplace, knock on wood. Let me explain where I'm coming from. Doesn't mean that we're not seeing lawsuits, doesn't mean someone couldn't attempt a case, but your workers' comp policy is one of your first lines of defense here, as beyond following all your safety practices and the CDC guidelines, et cetera. That policy should protect you from a negligence claim. That's what it's there for. If the allegation is that you just negligently failed to do something or put some working conditions on me and I caught it, workers' comp should kick in and protect you from a lawsuit. Now, you can lose that protection if the employee can establish that it was an intentional act. You threw them into the coughing den of COVID-19, something like that. Sometimes recklessness can get you there too. But I think as long as you're following the best practices, following the safety guidelines, Jeff gave a great overview, you should have a very strong case to keep this in the workers' comp world. It's hard to prove where someone caught it as well.
Thanks for that. Let's see, this looks like a pretty quick answer. Jeff, this is for you. Will my employee know it was me if I report them for fraud? And I'm not talking about me, the greater me.
It's a great question. And maybe Damon can help me on this one, but my understanding is that generally it could be a coworker that reports someone who's fraudulently claiming work if they're having to work extra hours and they don't want to work those extra hours. But likely there's going to be an indication that it's the employer, for the simple reason that it's the employer that's paying the premiums. And this is a sticking point for a lot of employers, but know that it's a safety net that's important for folks who are out of work. And so I understand, maybe Damon could help here. You're not paying dollar for dollar in premiums what your employees are receiving in benefits.
Definitely, yeah. I mean, I think it would probably be clear that the employer is probably the one, if you got notified that your claim is being investigated for fraud, you could probably assume it was your employer that submitted it, most likely, because as you said, they're the ones that are, ultimately it can affect the rates that they're paying as employers, the number of folks who are unemployed, and the frequency in which people are losing jobs through your business. So, yeah, you could probably assume that, but there's no way the employment department wouldn't actually tell a claimant that if they're being investigated that the actual complaint came from a certain particular person or entity or anything like that. But probably safe to assume that they would guess it was from the employer.
Okay, thanks for that. We have time just for this last question. The Family Leave Act is 25 employees and under in Oregon. And I do believe that's correct for paid family leave, some of the legislation that passed last year. But the EPSL is 50 or more. And why is it different? And if the businesses can show that it's a hardship, I guess the question I'm reading into this is, how hard is it to show hardship?
Hard to show the hardship, and actually those numbers are wrong. Let me clarify. Jeff, chime in and correct me if you think I'm off. In the old days, pre-COVID-19, and these rules still apply to the general laws, FEMLA and OFLA, Oregon Family Leave Act kicks in at 25 employees. FEMLA, federal, kicks in at 50 employees. Now, these new laws that I went over today, they're written backwards. It's 500 or less. You're at under 50, you're under 500, you're subject to these new laws. Now, the small business exception is briefly outlined in one of my slides. Again, it's got to be that childcare reason, less than 50 employees, and you have to be able to show that business jeopardizing threat. High standard to show. I would definitely, you can't get an advance opinion from the Department of Labor that, oh yeah, we qualify. They've expressly said, don't ask, but document it if you think you're going to rely on it. More importantly, get some legal advice on that one before you rely on it.
Thank you. Great. Well, gentlemen, we are out of time. I want to thank each of you. Truly a lot of great information today. And hopefully the folks who are watching can use that in running your business, and certainly tune in, because we'll be sharing this pre-recorded, and feel free to share it with others and get this great information out. So we'll send you the slides and all the resources that I mentioned earlier when we first started. And so you can share that and dig in and see if there are resources there that might also help your business as well. So one last word, thank you all for coming. If you currently are not a Bend Chamber member and you're interested in it, we would welcome you. And it takes the support of our members and our community to bring you programs like this. And certainly if there's anything that we can do for you, please let us know. You can contact us regarding membership at Shelley, SHELLEY @bendchamber.org, or just look us up on the web. And we really appreciate your time. Appreciate everybody's great expertise today. Go out there, happy Juneteenth, enjoy the sun, and we'll see you in a couple weeks. Thanks for attending today.
Great seeing you guys.